Hello everyone, welcome to Lukmaan IAS. Today we are going to have the Hindu newspaper analysis dated 17th of August 2023. In today's newspaper discussion, we are going to cover all those important articles that were there in the editorial section of the newspaper, and also we are going to cover other important areas that are important for the prelims and mains exam. Along with this, we have also included some questions for the prelims and mains exam. So with this, let us start the discussion. So these are the list of articles that we are going to cover in today's discussion, right? The list of articles, their relevance and page number is mentioned here. Along with this, we are going to cover these topics as well. So in all, we are going to cover about 9 topics today, okay? So let's start the discussion. This is the first topic. This topic is related to, right? Related to criminal jurisprudence in India. So in this topic, we are going to understand about some of the new laws that are that are being promoted by the central government. Means the central government is on the verge of introducing 3 laws that are going to change the criminal jurisprudence or criminal laws in India. So this topic is related to GS paper 2 of the mains exam, okay, under Indian polity, constitution and governance, okay. So this is related to that one, and this topic is going to be very, very important. Why it is important? Because through this topic we are going to understand about the ways in which criminal justice system has been functioning in India, okay. So let's start the discussion on this topic, right. So name of the topic is New Bills and a Principled Course. New Bills and a Principled Course for criminal law reforms. For criminal law reforms. So here, what is the context? The context is recently the central government has introduced 3 laws, right? One of the law is known as, this is known as Bharatiya Nyaya Sanhita, okay? One of the law is Bharatiya Nyaya Sanhita. This particular law is going to replace, right? It's going to replace the Indian Penal Code. Indian Penal Code 1860, okay? So it's going to replace Indian Penal Code. Apart from this, the central government has also, right, introduced another law which is known as Bharatiya Nagrik Suraksha Sanhita. Bharatiya Nagrik Suraksha Sanhita, okay? It is known as Suraksha Sanhita. So this is going to replace the criminal procedure code, okay? It is going to replace the criminal procedure code, okay? Procedure code. Apart from this, the government has also introduced another law. This law is known as Bharatiya Sakshya Bill, okay? Bharatiya Sakshya Bill, and this is Bharatiya Sakshya Bill, and this is going to replace Indian Evidence Act, okay? It is going to replace Indian Evidence Act. So today we are going to discuss about these changes that the government of India wants to bring, okay? So we are going to discuss about multiple dimensions of these things, okay? So let's discuss. So when we talk about these criminal legislations, right? So these criminal legislations that are in place, right, in India, if I talk about the Indian Penal Code, this Indian Penal Code belongs to 1860, right? So it's a colonial era act. This Indian Penal Code has been drafted, right, by the Britishers who have ruled over India. So like, and we had adopted them, and like, since then it has become a part of our criminal justice system in India. So the Indian Penal Code. What is Indian Penal Code? Indian Penal Code is let's say like is a code, right? It has multiple let's say sections, and those sections define what constitutes an offense, right? If somebody does any wrongful activity, whether this constitutes an offense or not. It also mentions about like, what can be the punishments related to this offense, right? The minimum punishment, maximum punishment, right? So it is mentioned in Indian Penal Code. If I talk about Criminal Procedure Code, so Criminal Procedure Code was again, let's say it had detailed provision that like if somebody has committed a crime, how that thing will be taken care of in a court of law, means like, how the, let's say, investigation should happen, like what the judges should look into. I mean like, so it is mentioned in Criminal Procedure Code. Then Indian Evidence Act. What is Evidence Act? Means it says like, what evidences are needed, right, to prove that someone is guilty or someone has committed a guilty offense, like that, okay? So it talks about the rules of evidence, right? So Indian Evidence Act. So all of these three will be changed, right, by these bills, right, once they become an act. So it is Bharatiya Nyaya Sanhita. So Bharatiya Nyaya Sanhita is going to replace Indian Penal Code. So they have not only changed the name of these acts, but they have also changed the contents of these, let's say like, acts that are that were already in existence. Okay, so they have changed the contents of it. Contents in the sense like they have, let's say, rationalized the wordings. Means earlier if there was a mention of, let's say, like offenses against the state, or which is known as defamation. So they have replaced defamation with some other term. And similarly, like through these acts, they have also introduced some new offenses. Some new offenses, for example, if I talk about name of these new offenses, so these new offenses are, right, these new offenses are, let's say, they are going to shape the way that criminal justice system is going to work in India, okay? So new offenses means like they have done away with terrorism, they have defined, right? They have done away with sedition, and they have defined some new offenses, right? They have defined, for example, they have defined what do we mean by terrorism, okay? Terrorism is also defined. Apart from this, they have also like, talked about organized crimes, okay? They have talked about organized crimes, okay? They have talked about organized crimes. Then they have mentioned about mob lynching, okay? Then they have mentioned about mob lynching. They have made mob lynching as a, let's say, a crime, right? Apart from this, they have mentioned about negligent acts too, and noble dimensions. So these are some of the new definitions of, right, new definitions of new kind of crimes that have been added. Apart from this, they have also changed, right, the existing definitions. So what effect it is going to bring? First of all, we need to see some of the things that the author has highlighted. The author is, let's say, like the Vice Chancellor of National Law University, Delhi. So this person holds great eminence in the field of law and justice, right? This person holds great, let's say, expertise in this area. So this person has mentioned that, like, many important things. What are the important things that has been mentioned? So we are going to discuss about those important aspects, right? Those important aspects. So this is going to be very important. So one of the important aspects that the author has said that, like, these three bills should not be allowed to be passed through the parliament without debate. I mean, like, many bills have recently been passed through the parliament, like, without much debate, because the opposition was busy, right, protesting against the injustice that has happened in Manipur, right? So opposition was busy, and during this time, the ruling government, the ruling party, they have made many laws, I mean, pass in haste, right? passed in hurry. So the author says that there should be proper debate, right? There should be proper debate in the parliament, and this debate will ensure that, like, those provisions that do not fulfill the, let's say, fulfill the concepts of criminal justice, right? They do not uphold the criminal justice system. Those things must be deleted, right? They must be deleted from the act, or they must be changed. Apart from this, the author has suggested that, like, after the debate, right, there should be other things also that should be looked into. What are the other things? Means, like, it's going to be a test, right? It's going to be a test not only for the parliament, okay? It's going to be a test not only for the parliament, but it's going to be a test for the judiciary also, because, like, once it is passed, the judiciary is something, is the body that's going to look after these acts, that's going to, let's say, like, have trials of criminals based on these acts. Apart from this, the author has also said another very important thing. What is that important thing? The author says that, like, all the stakeholders, right? All the stakeholders. Who are the stakeholders? These stakeholders are not only the government, but stakeholders are people at large, people of India at large. So when we talk about criminal justice system always, let's say, bring some notion of, let's say, like, some notions of contradiction. So it says, like, criminal justice system is a site of struggle and contradiction. Okay, so criminal justice system is a site of struggle and contradiction. So that's the thing. So there will always be contradictory ideas related to this. And the author has said that some reformatory measures that have been taken, that I have already discussed. And the author has talked about that there should be some test. Okay, there should be some test for these laws that are being passed. One of the things that the author has said, that the primary principle for such adjudication remains the extent to which reforms address the needs and concerns of those impacted by criminal justice. Okay. So we need to look into those people, right, who are going to affected, right, those people who are going to be affected by the criminal justice system. So those stakeholders concerns must be, okay, stakeholders concerns must be looked into. So that's an important thing that the author has said. And apart from this, the author has suggested, let's say, many such points. For example, following the principle of criminalization in creating new offenses is equally pertinent. Okay, so we need to let's say, like, follow the principle of criminalization. Means, like, what constitutes, right, what constitutes a criminal offense, right? So the principle of criminalization should be looked into. That is what mentioned by the author. Then criminal laws in this country further class divides. Okay, so one of the concern that the author has raised, that, like, like, criminal laws in the country, it creates a class divide. Why it creates class divide? Because the rich people, right, have the necessary resources to get the best lawyer to defend their case. However, the poor do not have it, right? So these laws that are, these bills that are being proposed by the central government, they should try to bridge the gap of class divide, so that the poor and the marginalized people should also have access to justice, and they should be having quality access of justice even if they do not have money, right? So the author says this particular thing, because in India, what happens, those people who have money, those people who are rich, right, even if they have committed some criminal offense, right, they get the best of the best lawyers, they get their cases, let's say, like, heard or defended by those lawyers, and, like, there is more probability of them winning. And at the same time, there are poor people, right, poor marginal people, there can be frivolous cases against them, but, like, because they do not have necessary know-how, they do not have necessary, like, the money, so they are unable to defend themselves. And many of these poor and vulnerable and marginalized people, they languish, right, in jails, because they have no one to defend them, they have no one to let's say like look after their cases. That's the thing. So that's why the author says that like this class divide should be bridged so that principle of natural justice can be upheld. And also it says, the author says that it is fallacious to assume without conclusive evidence to the contrary that the populace oppose stringent measures against terrorists or organized criminals. At the same time, increasing severity in laws does not ipso facto install public confidence in the criminal. I mean, here the author says, I mean, the language in which the author has written, it's very, let's say like, very high level legal type of language. So I'll make it simple for you. The author says that like, there is a popular perception about different crimes that happens in the country, right? There is a popular perception, and popular perception is shaped by the political ideology of the ruling party. The ruling party, let's say, enforces some kind of ideology into the society through different, let's say, medium, for example, through digital media, through television network and all. So the people like who are ignorant about like what constitute justice, right? So they have developed certain notion of justice, like without having a solid foundation. However, it says that like irrespective of what the popular opinion about a topic is, the judges should not refrain, right? They should not shy away. They should not refrain from giving justice based on sound constitutional principles, based on sound prudential principles, right? So the judges, judges and the Supreme Court of India, who is the guardian of the Constitution of India, it should make it sure that like justice is available to all, and also justice should be delivered as per the sound sound, let's say, principles or sound doctrines of justice delivery, right? So this is what is mentioned by the author. In your free time, you can go through the article once again. It is written in a very, very complex language, right? If you read it again, you will be able to understand a bit of it. However, I have explained it in the simplest of the words so that you can understand this thing, okay? So these things have not yet become law. Means like already the Indian Penal Code, Criminal Procedure Code, Indian Evidence Act, they are in existence, right? And these bills, these are only bills now. They will introduce it into the parliament. Once it is introduced, then there will be debates into the parliament. And once both the houses of the parliament, the, let's say, Lok Sabha, Rajya Sabha passes it, then it will go for presidential assent. So once the president signs, gives her assent, only then they will become laws, right? And these laws, since they are criminal laws, so they will be applicable, right? They will be applicable from the date on which it is enacted, right? So it will not have any retrospective effect, right? So it will be having prospective effect only, okay? So that's the thing. So with this, like, we will move to the next topic quickly, and also we will see if there are some questions for us to solve. Yes. So let's solve this question. This is question for the prelims exam. It says Bharatiya Nyaya Sanhita, okay? Bill 2023, recently seen in the news, seeks to repeal which of the following? This is just for your practice, right? I have just explained about it. So this Bharatiya Nyaya Sanhita is going to replace Indian Penal Code 1860. It's going to replace Indian Penal Code 1860. We have also given explanation to this question. You can download this video from the YouTube. Apart from this, we have another topic, right? This topic is again important. It says an act to cement digital authoritarianism, okay? So this topic is important under GS paper 2, right? And it is also important under GS paper 3. I'll make you understand both the context, right? However, here we have, let's say, included the syllabus of GS paper 2. Let's understand this thing, okay? So it says an act to cement digital authoritarianism. So in this article, we are going to understand about Digital Personal Data Protection Bill, okay, or Digital Personal Data Protection Act, because it has been passed through the Parliament of India. So the Digital Personal Data Protection Act, in this article, they have mentioned it the, Data Act. They have referred to it as Data Act. So Data Act means Digital Personal Data Protection Bill or Data Protection Act, okay. So 2023. So this Digital Personal Data Protection Act, right, seeks to, right, bring changes into the way that personal data are being protected. In this article, the author has taken a critical view, very critical view of the Digital Personal Data Protection Act, and also the author wants to, right, uncover, right, what is there in the Digital Personal Data Protection Act. So the author says that like this act, like an act to cement digital authoritarianism, means with this the central government wants to build a totalitarian state. Okay, totalitarian state. So what do we mean by totalitarian state? Totalitarian state means totalitarian state. So what is a totalitarian state? Where the government has, let's say, like, more authority, it has more power as compared to the people who are giving power to the government. For example, in India, we the people of India have chosen to give, let's say, power to the elected government, right, the government that we have elected to power. But it is going to bring a notion of totalitarian government, the authoritarianism, where the government officers, the government will have an upper hand, right, in curbing the rights of the people, right, giving selective treatment to people, right. So in this article, we are going to discuss about it, right. So it says an act to cement digital authoritarianism. Cement means to give more authority, right, for digital authoritarianism. So let's discuss about this article quickly. It says an act to cement digital authoritarianism. Okay, so what is the context for this topic? The context is related to the passing of the Digital Personal Data Protection Act, okay, 2023. So the government has recently passed the Digital Personal Data Protection Act 2023. This Digital Personal Data Protection Act, what it does, right, it creates different entities. One of the entities is known as data principal, okay, it is known as data principal. The other is known as data fiduciary, okay, data fiduciary. Apart from this, it also creates a body, okay, it creates a body, and this body is known as Data Protection Board of India, okay. So it is known as Data Protection Board. So Data Protection Board. So let's discuss about what is the role of which entity. So data principal are the users like me, you, citizens, right, organizations and all. So data principal are those people like whose data will be used, right, whose data will be used. Data fiduciary are the private entities, okay, they are private entities, means companies, okay, data fiduciary means companies. So data fiduciary can be private companies, right, they can be private companies, and they can be, let's say, like government companies. Government companies means public sector undertaking or enterprises. And what is Data Protection Board? It is the board, like, if there is any dispute related, like, between these organizations or between these people, like, between citizen and companies, or between companies and citizens, and between government and all. So it will go as an appeal to the Data Protection Board, and the Data Protection Board will have an authority to give judgment related to this, okay. So this is, like, a basic understanding about Digital Personal Data Protection Act. So the author says in this article that this Digital Personal Data Protection Act that the government has come up with, it dilutes, right, what it does, it dilutes, right? It dilutes data privacy. Okay, it dilutes data privacy. The author says that the name of the act is Digital Personal Data Protection Act. The name is this thing. However, the actual intent of the act is seen in the content of the act. The author says that the content of the act, does not promote data protection. What it promotes is data processing and data usage, right? So how it dilutes this thing? It promotes data processing by companies, right? Data processing by companies and the data usage by the companies. Okay, it promotes data processing and data usage. So it gives upper hand for the companies to use data of the consumers, data of the citizens, and also, right, it selectively categorizes the central government or government and the private entities. It says the private entities will have to furnish all data that the government requires from time to time, government and entity requires. And for furnishing those data, private data, right, the companies do not have to share it publicly. I mean, like, they do not have to notify that they have shared the data to the government. They only have to share. However, if the companies are using some data, taking some data from the consumers, from the, let's say, citizens, they have to talk about, like, for what purpose they are taking data, and also they have to talk about, like, how they are going to use the data. Okay, so this is the thing. So here in this article, the author has, given multiple points, where the government of India fails to protect the privacy of the citizens. So the author has mentioned about a judgment, which is Puttaswamy judgment. Okay, Puttaswamy case. In the Puttaswamy case, the Supreme Court of India has given a judgment in the year of 2023. And in that judgment, right, so there was a constitutional bench that was set up. Okay, there was a constitutional bench was set up. Constitutional bench consists of 5 judges of the, 5 senior most judges of the Supreme Court of India. So there was a sole judge, just one judge, right, Justice D.Y. Chandrachud. Okay, Justice D.Y. Chandrachud, where he has given a dissenting opinion. And apart from this, let's say, there they have mentioned, okay, so there they have mentioned that data privacy of the citizen is, right, data privacy of the citizen is a fundamental right, right? Privacy is a fundamental right of the citizens, and it can never be, let's say, breached. However, through the Data Protection Act, the government is enabling, right, data processing and data, let's say, usage. Here the author says that the government has made it in such a manner that government can access any data of the user at any point of time. And also, to complement this particular thing, the government of India has also come up with one thing, which is registration of births and deaths. Okay, they have come up with, let's say, they have amended the registrar general related thing. Okay, so that requires registration, right, of birth and death using Aadhaar cards. Means, like, when a child takes birth, his parents have to share the Aadhaar card, right, their Aadhaar card, and they need to get their birth of a child registered. And apart from this, when a person dies, right, in case of death also, right, there will be use of Aadhaar cards. Means the government has the authority to serve, to have, let's say, data of any type, including birth and death related thing, right, since the childhood and all. And if you want to avail any service from any private entities or government entities, right, there is a requirement of giving your, let's say, your identity, your data. So that can also be accessed by the government at any point of time. So the thing is, the author is saying that it is creating, right, what it is creating? It is creating an authoritarian state where the government can selectively deny to give, right, some government benefits to some marginalized sections of the society, right, and they will selectively, let's say, provide benefit to their own, let's say, people. So in this article, they have talked about that what government is thinking, like here in this article the author has given many examples including smart cities mission that talks about creation of integrated command and control center, right? And also the author says, like, nowadays if we go through metro, if we go anywhere, we see CCTV camera here, there and all, right? So they are always surveilling, right, us, where we are going, where we are not going. So like it will create a kind of surveillance state. It will give, let's say, authority to the government entities to, let's say, look into the details of every citizen of the country. So the author says that, like we need to be taking this particular thing as a warning for the citizens, and like all the people should collectively come to defend, right, their rights, to defend their privacy, right, to defend their privacy, like that. So ultimately the author says that the Digital Personal Data Protection Act is about total state control and having every Indian slip in the digital leash, right? Leash means digital boundary. So all of us will be, let's say, like हम सबको वो घेर लेंगे digital boundary में. It's like that. This is what the author wants to say through this article, right? So you can read this article to understand little more, because the author has given some examples also. Author also mentions that data principle or citizens have been given certain duties also as part of it. Okay, they have been given duties, and there are provision of applying penalty on citizens as well, right? So that's the thing. So with this, we have another topic. We are going to discuss this topic quickly. It says the future will not forgive the government. Okay, the future will not forgive the government. So this article has been written by the author to talk about two acts, right? Two acts. One of the act is known as the Forest Conservation Act. Okay, the Forest Amendment to the Forest Conservation Act. Amendment. Author has mentioned Forest Conservation Amendment Bill 2023. However, it has become an act. Right now, they have named it as Wan Sanrakshan Evam Samvardhan Adhiniyam. Right, and the author talks about another thing which is known as Biodiversity Amendment Bill. Okay, Biodiversity. Okay, Biodiversity Amendment Bill. So both these things have become act, and after this, right, although they have named it as Forest Sanrakshan Evam Samvardhan Adhiniyam, they have mentioned as Biodiversity Protection, let's say, Act. However, the exact intent of these things is not for protection of biodiversity, not for conserving the biodiversity, but like diluting the provision of conservation. Why? Because in this article the author has talked about, right, certain things. For example, like I will be writing about it quickly. So this is the future will not forgive the government. It says the future will not forgive the government. Okay, this is the topic. So in this topic, the author has discussed about these two acts that I have mentioned. One is the Wan Sanrakshan. Okay, Wan Sanrakshan Evam Samvardhan Adhiniyam, right? One of this is. Then second one, right? The Forest Biodiversity Amendment Bill. Okay, Biodiversity Amendment Bill or Biodiversity Amendment Act. Means like it has been, okay, amendment. I'm writing it as bill, however, it has been passed by the parliament, okay? It has been passed by the parliament, so it became an act, Biodiversity Amendment Act. So it is no longer a bill. So now we need to understand this thing. that government has come up with these things, and like in the first case of Van Sanrakshan and Samvardhan Adhiniyam, so the thing is like there was an act which is Forest Conservation Act, okay, Forest Conservation Act of, let's say, 1980. So in the Forest Conservation Act, there were many provision of conserving the forest. After then, there came a judgment of the Supreme Court of India. The judgment of the Supreme Court of India in Thirumalpad, okay, in Thirumalpad, Goda Varman case, okay, in Thirumalpad, Goda Varman case. So in that case, the Supreme Court of India in 1996 has decided that all those areas that meet the dictionary definition, right, that meet dictionary definition of forest, right, that meet dictionary definition of forest, so they will be considered as deemed forest. Means in the 1980 Act, there was mentioned like what constitutes forest, what does not constitute forest. They have also mentioned what constitutes deemed forest. To increase the scope of protection, so the Supreme Court of India has given a judgment in this case, and they have widened the scope of deemed forest. And after this, what has happened means like, various things came, various, let's say, like places that meet the definition of forest, they came under forest conservation, regardless of their ownership, whether they are under private hands or government hand. So that was the thing. However, now what has happened, now the thing is, now the government of India came up with this act, Van Sanrakshan Evam Samvardhan Adhiniyam. Under this, like, all those places that are deemed forest, right, from 1980 onward, they will be, let's say, protected. However, the deemed forest after the 1996 judgment, they will not be protected. So the thing is, this particular act dilutes the Supreme Court judgment. And this is what is being, let's say, like criticized by the people. That's why the author says that the future will not forgive the government, because our next generation, the future generation that they are going to come, they will not be having as much environment, right, as much biodiversity as we are having at this point of time. Why? Because the government has, opened the forest areas for clearance for the private, let's say, gains for the private people, because the non-notified areas that are still forest can be diverted for non-forestry purposes, can be diverted for private interest, can be diverted for let's say establishing companies, establishing, let's say, like, tourist resorts and all for private gains. So that's why the author is saying that the future will not forgive the government. So with this, like, we will move to the next topic quickly. So we have two questions for you. One of the question is for the mains exam. I will read this question for you. It says, what are wetlands, right? What is Ramsar Convention on Wetlands? Okay, Ramsar Convention on Wetland. Discuss the steps taken by India to protect the wetlands. Okay, so this is the thing. You need to write this answer, and after writing, share it with us on the email that we have already shared. Then, like, we have a question for you. This question says, with reference to wetlands, consider the following statements. One of the statements says, they are the great carbon sinks. Okay, wetlands are definitely, they are great carbon sinks. They can filter out pollution from water. Third, this is also right. Llanos de Moxos is the world's largest protected wetland located in Bolivia. All these three statements are right, means correct answer would be option C. Option C is the right answer. We have also included, right, an explanation to this question, right? So you can go through the explanation. In your free time, we have also talked about what is a wetland. So wetland is a place in which the land is covered by water. It can be salty, fresh water, or somewhere in between, right? Marshy water, like that. So you can go through the details in your free time. Then we have another topic, right? So we are going to discuss about this topic now. It says, Vishwakarma scheme will aid 30 lakh artisan families, right? So recently on the Independence Day speech, the Prime Minister of India has talked about this particular scheme, which is known as Vishwakarma scheme. The Prime Minister of India discussed about Vishwakarma scheme. So what is this scheme all about? this scheme is going to benefit, right? It's going to benefit people who are artisans, right? Who do manual work. For example, right? People, people who do these activities. For example, the traditional carpenter, boat maker, armorer, blacksmith, hammer and toolkit maker, locksmith, goldsmith, potter, sculptor, stone breaker, cobbler, mason, basket, mat and broom maker. So these people will be given benefit under this Vishwakarma scheme. So under this scheme, these people will be getting PM Vishwakarma certificate and ID card. So under this, these craftsmen and these let's say artisans, they will be trained to refine their products more. They will be trained how to sell these products, let's say through digital market. So they will be skilled to increase the quality of their product, and they will be skilled to sell it at a let's say at a wider market. And those people who are going to get certificate, right, who are going to get certified through this scheme, so they will also be given 500 rupees per day during the time that they attend the course. Okay, so they will be given a stipend of rupees 500 per day, right? These people will be provided. So this is the thing, and this scheme, I mean, will, the Prime Minister has said that it is going to bring back the Guru Shishya Parampara. Okay, so that's the thing. So it says the Cabinet Committee on Economic Affairs on Wednesday approved the PM Vishwakarma scheme. So that's the thing. Okay, so I hope you might have understood this scheme, right? So this is a newly introduced scheme, and Cabinet Committee on Economic Affairs has already approved this scheme. So it is going to be beneficial for these artisans and craftsmen. So with this, we have another question. This question is for the mains exam. It says, what is Vishwakarma Yojana? Discuss the main objective and significance of Vishwakarma Yojana. Okay, discuss the main objective and significance of Vishwakarma Yojana. So this is, you need to write this answer in 150 words again. So let's move to another topic. This topic is important. It says, understanding the Ministry of Environment, Forest and Climate Change's U-turn, okay, and MoEFCC. MoEFCC is Ministry of Environment, Forest and Climate Change. So they have taken a U-turn. On what topic they have taken a U-turn? We need to understand that. So, few years back, I think 2 years back, this ministry, right? So in June, this particular ministry has decided that they are going to bring together these organizations. Which organization? The Forest Survey of India, National Tiger Conservation Authority, the Wildlife Crime Control Bureau and the Central Zoo Authority. So they wanted to bring all of them together in one building, right? Means in whichever state they are located. So in those states, these bodies, right, their offices will be brought together in one place. So they are going to create regional centers. So this decision was taken by the government, and those regional centers will be headed by an officer, and that officer will be, let's say, answerable to the Minister of Environment for Climate Change, okay, or Ministry of Environment, Forest and Climate Change, right? So this particular move has been contested by people. There were cases filed in high courts earlier, and in those cases the people have said that when government brings together all these bodies will not be having any further autonomy, and the conservation of these species will be done away with. Okay, so it will be done away with. So that's why people have suggested, right? People have suggested that they should not be brought together, because if I talk about this Forest Survey of India, it comes up with a report, and if the National Tiger Conservation Authority finds that this report does not reflect some of the things correctly, so in that case they, as of now, they, let's say, raise issue related to this, and if they are on the same building, their autonomy will be compromised. So that was the thing. So initially the government has decided that they are going to bring together these bodies, right, in same offices. However, later on, now the government has, let's say, taken a U-turn in its decision. Now they don't want to bring these bodies together. Why they don't want to bring? Because they have cited that there will be administrative challenges, right? Because these organizations' offices are located at different places. So there will be organizational challenges. So that's the thing, okay? So with this, In this article, they have mentioned that what is NTCA, what is National Tiger Conservation Authority. The NTCA is the managing authority of Project Tiger and India's tiger reserves. Then what is Forest Survey of India? The Forest Survey of India is a scientific body that primarily deals with forest data. And then WCCB is an enforcement authority. Then it has also mentioned that Central Zoo Authority purview is limited to functioning of zoos only. Okay, so that's the thing. I mean, like, their bodies, these bodies functioning has also been mentioned here, right? So here, like, we have a question again. So it says, with reference to National Tiger Conservation Authority, it provides a statutory authority to Project Tiger. So basically, I mean, like, this statement might seem to be difficult for you to understand. However, like, here we are talking about National Tiger Conservation Authority. So this National Tiger Conservation Authority looks after Project Tiger. One of the objective of this authority is providing a statutory authority to Project Tiger. Means Project Tiger is a project of the government, but which body is going to look after that project? It is going to be looked after by National Tiger Conservation Authority. So this authority it's one of the objective is that, like, it will provide a statutory authority to Project Tiger. And apart from this, the National Tiger Conservation Authority also, let's say, administers all the 53 tiger reserves in India. Okay, so that's the thing. So this is right. If you see the objective of this body, so you will understand this thing, right? It is mentioned in the objective. So that's the thing. Second, it is constituted under Environment Protection Act, right, 1986, right? So this statement is incorrect. So let's see this thing. Okay, so let's see this thing. I think this is also correct. So here, both these statements are correct. The correct answer would be, like, so here they have mentioned one is incorrect, so that's correct. So correct answer would be option C. Okay. Second statement is incorrect. First is correct, second is incorrect. Yes. So A will be the right answer. Second, it is constituted under Wildlife Protection Act 1972. First is right, second is wrong. Okay, so here the answer is, let's say, given in a different format. What I'll do is I will get this PPT edited and, like, we will upload the right version of it. Means, like, here it will be mentioned correct, it will be mentioned incorrect. So that will make this answer to be right. I mean, like, here everything is right except those things. Okay, so correct answer would be statement 1 is right and statement 2 is wrong. Okay, because it is not created under Environment Protection Act, it has been created under Wildlife Protection Act of 1972, the National Tiger Conservation Authority. Okay, so with this, like, we have another topic. This topic is important. We are going to look into this topic quickly. It says, why is Bihar's caste-based survey facing legal challenges? Why is Bihar's caste-based survey facing legal challenges? So we need to understand this thing quickly, right? So recently the Bihar government, last year they have, released a notification, the government of Bihar, that they want to conduct a caste-based survey in the state of Bihar. And this year in January, right, they have started a project, right? So they have started a project. So on January 7th, the state government launched two-phase caste survey in Bihar, okay? And why they have launched the caste survey? They have said the official rhetoric or official position is that, like, they want to understand what is the caste composition in Bihar so that government can make proper policies, right, that are targeted to give benefit to these, like, let's say, like, backward caste in the state of Bihar. However, this was contested in the, High Court of Bihar. So, like, in the Patna High Court, I think, right? So in in the High Court, what has happened in Patna High Court, it was challenged, and the Patna High Court has, heard from both the sides, and Patna High Court has upheld the decision of the Bihar government. Okay, Patna High Court has upheld the decision of Bihar government to conduct a caste-based survey. Now, the person who has challenged the state government's decision to conduct a caste-based survey, that person said that constitutionally it is mentioned that caste-based survey can be conducted only by the union government, right? It cannot be conducted by the state government. However, since the state government is doing it, so it is unconstitutional. That was the stand of the person. However, the High Court has ruled that, like, the intent of the government is giving benefit to the, let's say, backward caste, and for that, like, it has to do caste-based survey. It cannot wait for the central government to take up such a project for the state government. So citing this, the Patna High Court has given a verdict, right, in favor of the Bihar government to conduct a caste-based survey. And also, after this, so this has again, this particular issue has come up with come up to the Supreme Court of India. Now the Supreme Court of India is going to let's say, like, conduct hearing on this particular case. Supreme Court is going to conduct hearing, and after then it is going to take a decision whether the judgment of the Patna High Court was right or wrong, right? So along with this, like, we will talk about another topic which says center's draft SOP wants courts to exercise restraint. Okay, so recently the central government has, let's say, like, released a standard operating procedure. Okay, standard operating procedure, which is in short known as SOP. So this SOP is a kind of 5 to 6 page manual. In that manual, it has mentioned that the courts, right, court should have restraint before summoning any government official, right? Because, like, it has been recently noticed that the courts summon government officials. They, let's say, like, they speak very harsh to the government officials for their, let's say, contempt on court orders, for their, let's say, like, like misbehavior, for their inappropriate dressing in the court. So there have been multiple, let's say, such instances. So that's why government has released this standard operating procedure. Now the thing is, we need to see that, like, government is an executing authority, executive body. Judiciary is a separate body. Okay, judiciary and government, so they are at a principled distance from one another. Okay, so there is, let's say, division of, let's say, authority between them. Whether this particular standard operating procedure, I mean, like this SOP, right, that says the courts to exercise restraint, right, will it be taken, let's say, like, positively or negatively by the courts? It depends on the courts. The courts, I mean, like, they can summon any government official. It is under their authority. Why? Because if they do not summon any government official, then government official will be negligible to uphold, right, and do its part on the judgments, on the decisions that are taken by the courts. Okay, so that's the thing. So this standard operating procedure, I mean, like, we need to see that, like, how this particular draft will be taken by the courts of law in India. So this mentions that official ought to be summoned only in exceptional circumstances and not as a routine. Okay, that's the thing. This is what is mentioned. Then apart from this, we have another topic. This topic is again important. It says Supreme Court unveils a handbook to eliminate gender stereotypes from law. So we know there are many things in this society. For example, if a woman is going to work, right? So generally people say this is a work woman. In the sense, they imply that this woman does not, right, give due importance to the family affairs. She is not a family oriented person. So this gives a perception. So that also gives gender stereotyping. Okay, so there are many such terms, right, many such terms. For example, career women, fallen women, faithful, obedient wife, Eve teasing, let's say, like, hermaphrodite, etc. So these terms are gender stereotyping. So recently the Supreme Court of India has released a handbook. In that particular handbook, they have mentioned that these are the gender stereotyping words, and these words should not be used by the judges, right? These words should not be used by the judges while, let's say, delivering judgments. Why? Because, like, it gives gender stereotyping. Although the whether these words are spoken or not, the judges give judgment on a case based on the merits of the case, based on the evidence, based on the, let's say, like, let's say, established rules, right, established rules. However, it does not color their opinion. However, the Chief Justice of India has said that, like, words are the vehicles through which the, let's say, judges deliver their justice. So what should be spoken in a right manner, in a dignified manner, so that gender stereotyping does not happen with the justice delivery system itself. Okay, so that's the thing. So you can read this article to understand it a little more, right? Some of those words is also mentioned, and they have also, let's say, what is the name of the book? This is known as Handbook on Combating Gender Stereotypes. Okay, Handbook on Combating Gender Stereotypes. That's the thing. So with this, we came to another topic. This topic says expansion of Digital India program gets 14,903 crore outlay. Okay, so through this topic we are going to understand about Digital India program. Government of India has come up with Digital India program long back. It's been, let's say, like, this program is about to expire, so the Government of India has given an extension to this project, which is Digital India program. It has given an extension, 5-year extension to this particular project. Apart from this, they have also expanded, right? Expanded or expansion. They have given expansion to Indian Computer Emergency Response Team, which is also known as CERT-IN. Okay, CERT-IN. CERT-IN. Okay, one is Digital India program, DI program, Digital India program. Other is this thing. So here they have just mentioned about it, that, like, it is going to it's going to foster the digital growth in India. So it says the unified mobile application for new age governance platform, which offers about these services and all. So it mentions about this. So this is a short topic. So that's all, like, for today's session. Thank you so much everyone for attending today's discussion. I hope you have a good day ahead. Thank you.